Lifeblood theory. Taxation is the indispensable and inevitable price for civilized society. Without taxes, the government would be paralyzed for lack of motive power to activate and operate it. Principles of a sound tax system. FAT. Fiscal adequacy. Sources of government revenues must be sufficient to meet government expenditures and other public needs. Administrative feasibility. The tax system should be capable of being effectively administered and enforced with the least inconvenience to the taxpayer. Theoretical justice. A sound tax system must be based on the taxpayer's ability to pay theory. Taxation must be uniform and equitable. Inherent limitations of taxation. Public purpose. International comity. Non-delegability of the taxing power. Exemption of the government. Situs or territoriality. Specific or direct constitutional limitations. P2UTO. Serve jail. Prohibition against imprisonment for non-payment of poll tax. Progressive system of taxation. Uniformity and equality of taxation. Delegated authority of the President to impose tariff rates, import and export quotas, tonnage and wharfage dues. Origin of revenue and tariff bills and appropriations. Prohibition on use of tax levied for special purpose. Votes required to grant tax exemptions. Tax exemption of religious, charitable, and educational entities. Present veto power. Non-impairment of Supreme Court's jurisdiction. Non-appropriation or use of public money for religious progress. Non-taxability of non-stock, non-profit educational institutions. LGU's power to create its own sources of revenue. Tax exemption of properties actually, directly, and exclusively used for religious, charitable, and educational purposes. Art 6 Sec. 28-3 of the Consti provides that charitable institutions, churches and personages or convents appertenent thereto, mosques, non-profit cemeteries, and all lands, buildings and improvements, actually, directly and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. While the court allows a more liberal and non-restrictive interpretation of the phrase exclusively used for educational purposes, reasonable emphasis has always been made that exemption extends to facilities which are incidental to and reasonably necessary for the accomplishment of the main purposes. Tax laws are interpreted liberally in favor of the taxpayer and strictly against the government. General rule. In the interpretation of statutes levying taxes or duties, the rule is not to extend their provisions beyond clear import of the language used. In case of doubt, such statutes are construed strongly against the government. Exception. In the matter of tax exemptions, in which case the tax exemption is construed strictly against the taxpayer. Non-stock, non-profit hospitals become taxable on income derived from activities conducted for profit. Although a non-stock, non-profit hospital organized for charitable purposes is generally exempt from income tax, it becomes taxable on income derived from activities conducted for profit. Services rendered to paying patients are considered activities conducted for profit which are subject to income. The hospital is subject to income tax of 10% of its net income derived from the paying patients considering that the income earned appears to be derived solely from hospital-related activities. Requisites of a valid tax. Person or property taxed must be within the jurisdiction of the taxing authority. Assessment and collection of certain kinds of taxes guarantee against injustice to individuals. It should for a public purpose. Note, it does not only pertain to those purposes which are traditionally viewed as essentially government functions such as building roads and delivery of basic services but also includes those purposes designed to promote social justice. It must be uniform. It must not impinge on the inherent and constitutional limitations of taxation. Requisites of an obnoxious double taxation. There is double taxation if respondent is subjected to the taxes being imposed on the same subject matter, for the same purpose, by the same purpose, within the same taxing jurisdiction, for the same taxing periods, and of the same kind or character. International juridical double taxation. The imposition of comparable taxes in two or more states on the same taxpayer in respect of the same subject matter and for identical periods. It usually takes place when a person is a resident of a contracting state and derives income from or owns capital in the other contracting state and both states impose tax on that income or capital. Compliance with the requirements of amnesty law entitles the taxpayer to its benefits. The completion of the requirements provided under the tax amnesty law shall be deemed full compliance with the tax amnesty program. The taxpayer shall thereafter be immune from the payment of taxes and additions thereto, as well as the appurtenant penalties under the NIRC, arising from failure to pay any and all internal revenue taxes. Tax amnesty. It is the government's absolute forgiveness, waiver, exercise of a general pardon, or international condonation of its right to collect past due and unpaid tax collectibles, including imposable penalties on persons guilty of evasion or violation of a revenue or tax law, giving tax evaders who wish to relent and are willing to reform a chance to do so. Dividends mean any distribution made by a corporation to its shareholders out of its earnings or profits and payable to its shareholders whether in money or in property. Intention to opt for the 8% income tax rate must be expressed by the taxpayer in the first quarter income tax return or the initial quarter return of the taxable year when the taxpayer commenced business. Withholding taxes versus indirect taxes.
Indirect taxes,
Like VAT and excise tax, are different from withholding taxes. To distinguish, in indirect taxes, the incidence of taxation falls on one person but the burden thereof can be shifted or passed on to another person, such as when the tax is imposed upon goods before reaching the consumer who ultimately pays for it. On the other hand, in case of withholding taxes, the incidence and burden of taxation fall on the same entity, the statutory taxpayer. The burden of taxation is not shifted to the withholding agent who merely collects, by withholding, the tax due from income payments to entities arising from certain transactions and remits the same to the government. Requisites for deductibility of property previously taxed vanish ang deductions DPIN. Death. The present decedent died within 5 years from the receipt of the property from a prior decedent or donor. Identity. The property sought to be deducted is the one received from a prior decedent or donor. Previously determined and paid. The donor's tax on the gift or estate tax on the prior succession was finally determined and paid. Inclusion. The property must have formed part of the gross estate situated in the Philippines of the prior decedent, or the total amount of the gifts of the donor, and no previous deduction o vanishing deduction on the property was allowed to the estate of the prior decedent. Note: property must still be part of the gross estate of present decedent. Requisites for deduction of family home ATL. The family home must be the actual residential home of the decedent and his family at the time of his death, as certified by the barangay captain of the locality where the family home is situated. The total value of the family home must be included as part of the gross estate of the decedent, and allowable deduction must be in an amount equivalent to the lowest of the current fair market value of the decedent's family home. The extent of the decedent's interest, whether conjugal, community or exclusive property, or 10 milyon. Note: deduction for family home is not applicable to NRA. If the family home is a conjugal or community property, the amount to be deducted is equivalent to kalahati of the fair market value but shall not exceed P10 milyon. Donor's tax. Transfer for less than adequate and full consideration is deemed a gift. GR, if the property transferred is for less than adequate and full consideration in money or money's worth, the amount by which the FMV exceeds the consideration shall be deemed a gift and be included in computing the amount of gifts made during the calendar year. Exception: transfers made in the ordinary course of business, a transaction which is a bona fide, at arm's length, and free from any denetive intent, even if the consideration is inadequate in account, is excluded. Destination principle and cross-border doctrine. According to the destination principle, goods and services are taxed only in the country where these are consumed. In connection with the said principle, the cross-border doctrine mandates that no VAT shall be imposed to form part of the cost of the goods destined for consumption outside the territorial border of the taxing authority. Sales to Ecozone deemed exports. While an ecozone is geographically within the Philippines, it is deemed a separate customs territory and is regarded in laws as foreign soil. Sale by suppliers located outside the borders of the ecozone to this separate customs territory, or ecozone, are deemed exports and treated as export sales. 120+30 train, 90+30-day periods are mandatory and jurisdictional for filing judicial claim of VAT refund. The taxpayer can file its administrative claim for refund or credit of VAT at any time within the 2-year prescriptive period. If it files its claim on the last day of said period, it is still filed on time. The CIR will have 120 days, 90 days, from such filing to decide the claim. If the CIR decides the claim on the 120th, 90th day, or does not decide it on that day, the taxpayer still has 30 days to file its judicial claim with the CTA, otherwise, the judicial claim would be dismissed for being filed out of time and not prescribed. Requirement for claim of utilized input VAT. A claim for refund or tax credit for unutilized input VAT may be allowed only if the following requisites concur, namely: the taxpayer is VAT registration. The taxpayer is engaged in zero-rated or effectively zero-rated sales. The input taxes are due or paid. The input taxes are not transitional input taxes. The input taxes have not been applied against output taxes during and in the succeeding quarters. The input taxes claimed are attributable to zero-rated or effectively zero-rated sales. For zero-rated sales, where there are both zero-rated or effectively zero-rated sales and taxable or exempt sales, and the input taxes cannot be directly and entirely attributable to any of these sales, the input taxes shall be proportionately allocated on the basis of sales volume, and the claim is filed within 2 years after the close of the taxable quarter when such sales were made. Fraudulent return implies intentional or deceitful entry with intent to evade the taxes due. False return contains wrong information whether due to mistake, carelessness, or ignorance. Requisites of the waiver of statute of limitations. The waiver must be in the proper form prescribed by RMO 20-70. The waiver must be signed by the taxpayer himself or his duly authorized representative. In the case of a corporation, the waiver must be signed by any of its responsible officials. The waiver should be duly notarized. The CIR or the revenue official authorized by him must sign the waiver indicating that the BIR has accepted and agreed to the waiver. Both the date of execution by the taxpayer and date of acceptance by the Bureau should be before the expiration of the period of prescription or before the lapse of the period agreed upon in case a subsequent agreement is executed. The waiver must be executed in 3 copies, the original copy to be attached to the docket of the case, the second copy for the taxpayer and the third copy for the office accepting the waiver. Note, if without the execution of the waiver of statute of limitations, the right of the BIR to assess should be considered prescribed 3 years after the last day prescribed by law for the filing of the return or from the date of actual filing of the return, whichever comes later. Note further, the general rule is that a defective waiver cannot extend the prescriptive period. However, take note that when the taxpayer is also guilty of causing defects in the waiver, i.e. in bad faith, the waiver shall still be considered valid and shall thus serve to extend the period to assess and/or collect. Jeopardy assessment when proper. It is one issued by the commissioner if he believes that the collection of taxes is in jeopardy. It may be issued when the taxpayer is retiring from business subject to tax, intending to leave the Philippines, remove his property therefrom, or hide or conceal his property, or performing any act tending to obstruct the proceedings for the collection of the tax. Willful blindness doctrine. A taxpayer can no longer raise the defense that the errors on their tax returns are not their responsibility or that it is the fault of the accountants they hired. CTA and bank cannot annul judgment of their divisions. Fundamental principles. The following fundamental principles shall govern the exercise of the taxing and other revenue-raising powers of local government units. Taxation shall be uniform in each local government unit. Taxes, fees, charges and other impositions shall be equitable and based as far as practicable on the taxpayer's ability to pay. Be levied and collected only for public purposes. Not be unjust, excessive, oppressive, or confiscatory. Not be contrary to law, public policy, national economic policy, or in restraint of trade. The collection of local taxes, fees, charges and other impositions shall in no case be let to any private person. The revenue collected pursuant to the provisions of this code shall inure solely to the benefit of, and be subject to disposition by, the local government unit levying the tax, fee, charge or other imposition unless otherwise specifically provided herein, and each local government unit shall, as far as practicable, evolve a progressive system of taxation. When questioning the constitutionality or legality of an ordinance, the appeal to the Secretary of Justice is mandatory. Sec. 187 requires that the dissatisfied taxpayer who questions the validity or legality of a tax ordinance must file his appeal to the Secretary of Justice within 30 days from effectivity thereof. In case the Secretary decides the appeal, a period also of 30 days is allowed for an aggrieved party to go to court. But if the Secretary does not act thereon, after the lapse of 60 days, a party could already proceed to seek relief in court. These three separate periods are clearly given for compliance as a prerequisite before seeking redress in a competent court, and these provisions of statutes is construed as mandatory. Hence, failure of a taxpayer to interpose the requisite appeal to the Secretary of Justice is fatal to their cause. Assessment is an act or process of determining the value of a property or proportion thereof subject to a tax. Appraisal is an act or process of determining the value of a property as of a specific date for a specific purpose. Payment under protest is a mandatory requirement when there is a question as to the reasonableness of the amount of real property assessed. Sec. 252 of the LGC provides that no protest shall be entertained unless the taxpayer first pays the tax. There shall be annotated on the tax receipts the words paid under protest. The protest in writing must be filed within 30 days from payment of the tax to the provincial, city treasurer, or municipal treasurer, in the case of a municipality within metropolitan area, who shall decide the protest within 60 days from receipt. Failure to comply with this mandatory requirement is fatal, and any appeal shall not be entertained by the LBAA.